So welcome to today's webinar. My name is Bethany Servin and I work in marketing here at UsableNet. This webinar is produced by UsableNet, a recognized leader in accessibility and digital inclusion. And our first speaker, Jason Taylor, Chief Innovation Officer. I'll hand it off to Jason now for intros and agenda. Jason?
Thanks, Bethany, and thanks everybody for spending a little time with us today. We're really pleased to have Christine Waltz, who's got a breadth of knowledge and experience in this space. I'm going to basically be sort of MC, and hopefully Christine is going to basically bring a lot of color to the subjects that we got today. Maybe Christine, you could do a little introduction to yourself and your firm. That would help us set context.
Sure. I'm Christine Walls. I am a partner in Holland & Knight's New York office. My practice focuses on helping clients navigate the legal issues impacting accessibility in both a web context and the brick and mortar context. I've been doing this type of work for almost 15 years and can talk some today about how the landscape has changed and what you can do to help protect your companies from the legal risks and provide accessible content to reach all of your customers and clients.
And from an agenda point of view, we're gonna try to do a quick recap, sort of almost like set the scene with regard to the legal landscape right now in 2024. Christine's going to help us with sort of understanding any regulational sort of updates and how they may affect the ongoing use of ADA in particular as a means of claiming inaccessibility in the web space. We're going to look at what you do if you get a claim, what's the options, what are sort of the roadmap there, and try to give you some key takeaways. Throughout this, you're going to hear some numbers around lawsuits specifically related to websites and apps. And just to give you context there, UsableNet has published for over 5 years a report twice a year. We essentially report on all of the activity around websites and legal claims associated with a digital space. So just so people understand how we go about that, essentially, we track both federal and state filed ADA claims. We look at every one of those claims and separate out when the subject matter is a physical location over a digital location. And then we track only the digital components. So if the lawsuit is brought against someone not being able to use a website or an app, those are cases that we report on. If a lawsuit is about whether someone couldn't use a physical location, we filter those out. So you'll see us reference some of those numbers, and we'll start with that just to sort of set the scene. One of the things that we've seen in 2023, throughout 2023 and starting in 2024, is that the overall number of cases are about the same in 2024 over 2023. There might be a little bit more collectively, but I think the main thing about this is that these lawsuits are large in number. So 4,500 in a year, that's around about 100 a week. So every week, 100 new companies typically are sued either in federal court or state court. And the claim essentially is mainly around an inaccessible website. There's a smaller number about inaccessible ADA claims. There's a couple of numbers in here that maybe I'll bring Christine to talk about. So out of those cases, 4,500 cases, about 80% of those are brought by a group of 10 to 15 plaintiff firms and around 10 to 25 plaintiffs. So in general, this is not 4,500 people who have had problems and individually go out and get 4,500 lawyers to represent them. There is very much a focused effort. Maybe, Christina, you could talk about that effort and how you've seen that grow over the last 5 years.
Yeah, absolutely. So when these cases first started being filed in the, let's say, early 2010s, we saw plaintiffs, disability rights groups bringing some large cases against big online companies or companies doing business online in order to, I'd say, make law and change where the law was. Today, and there were one or two targeted lawsuits, right? We saw Target get sued in the Ninth Circuit. We saw Netflix get sued in the District of Massachusetts. We saw Scribd get sued in Vermont, but they were cases brought by the National Association of the Blind and the Deaf in order to, again, move or change the legal standard. And they were a few number of large lawsuits. Today, as you've seen, we see a lot of pretty small lawsuits filed. They are form complaints. They are the same named plaintiffs routinely appearing, and they are the same plaintiffs' firms bringing the lawsuits. And that is, they have what I would call a volume practice, suing as many companies as they can. They are serial plaintiffs, and it is what I would call a cottage industry.
That's a great sort of foundation for us to move on from, and I think it sets an early picture. And I'm going to actually ask you a little bit more about this sort of typical month, right? You know, as I said, we track these lawsuits and we try to sort of dig into them, mainly trying to make sure that we understand the trends and help our clients understand maybe their risk factors around receiving these claims, right? But you know, a typical month looks like 300 plus lawsuits. You know, as I said before, like a lot of these are aimed around a particular set of law firms. One thing I wanted to get maybe Christine to talk about is, out of those 300, 50 of them are lawsuits brought against companies that have already received a similar lawsuit in the last 5 years. And I wanted to get your sort of practical understanding of why is it possible for companies to be sued multiple times under the ADA?
Yeah, so these cases are typically pled currently as class actions. They are, there's a named plaintiff that brings the lawsuit, and they allege that a class of individuals, one or more classes of individuals, have been harmed by an inaccessible website. But although these cases are class-based complaints, they are typically settled before a class is certified, and therefore they are settled on an individual basis, primarily, with just the named plaintiff. And because of that, the settlement only applies to the named plaintiff, and other individuals that are harmed could also bring a suit because they are not bound in any way by the settlement agreement. There is an option in cases to settle a case as a class-based settlement, but those settlements are much more complicated and much more costly, both in terms of what you would be paying in order to settle with each of the harmed class members or allegedly harmed class members, and what you'd be paying in legal fees to both your lawyer and to the plaintiff's lawyer in order to achieve those settlements.
So I'll read this back and summarize it. And there's maybe one other point I'd make about that number that we talk about, where 50 of the defendants are defendants that have been defendants before in the last 5 years, right? Christina's saying, well, you're really only settling your lawsuit, you're settling against one individual, which means if someone else got harmed the next day, which means you haven't quite remedied your site, there's nothing stopping them actually suing you. The other thing that we see a lot of is companies that have multiple websites. So the first lawsuit is just on one website. It's not a settlement across all of their websites. And that obviously means that if they're successful suing a company that has 5 websites, but they're successful on the first one, they quickly come back for the second, third, fourth, and fifth. What that practically means is if you did receive a website, you need to take it seriously, not just making sure that the website that you got sued on, you make accessible as quickly as possible. You want to look at anything else that's publicly facing that could potentially be sued, because essentially, as Christina's saying, this is a small group of plaintiff firms. They see everybody who gets sued. They know that if a company settles, that's a company that, if they've got more websites, that's an opportunity for another lawsuit. So that's why we see a lot of repeats on those. The other thing that I wanted to pull out here from the monthly is the focus of states. So New York, California, and Florida represent 80 to 90% of the cases. New York now represents at a federal and state level almost 70% of the cases. And I wanted Christina to ask 2 questions. Why, in very brief world, why New York is so heavy? And also, if you're not headquartered in New York, are you safe?
Yes. So the reason we are seeing this is because there have been a number of cases. Plaintiffs have had success in New York. They have had a few very good cases where the court said, if you're doing business in New York, you have New York facing customers. Certainly if you're a retail website doing business, like selling products into New York, your site has to be accessible, right? In other states, including both California and Florida, we've seen courts chipping away at that, or saying there has to be a nexus between a physical location, that brick and mortar location that we talked about, and the website. We know that's the standard in California. And in Florida, which is in the 11th Circuit, the 11th Circuit said in the Winn-Dixie case that websites didn't need to be accessible at all. And so given the sort of plaintiff-friendly and accessibility-friendly cases from New York, plaintiffs are choosing to file their lawsuits in New York, not in these other states.
Great.
And sorry, you had a second part to your question.
Exactly.
If your company is not headquartered in New York, are you safe? And I would say no. If you're doing business in New York, a New York court is going to say, we're going to exercise jurisdiction over you, and specific jurisdiction regarding what you're doing in the state. And so you can absolutely be sued in New York, unless you're not selling to any New York customers and aren't making your site accessible in the state.
And I think we'll come on to this a little bit later, but this is the interesting aspect of, in general, laws which are passed statewide on digital properties, because in the past, when a state passed laws around its physical properties, it potentially is mostly just affecting companies which are located in that state. But if a law is passed in California to say that you've got to, if you provide an e-commerce site to Californians, it's got to be accessible. Essentially, that California law is affecting every company in America. So that will be an interesting component that we'll talk about a little bit later in terms of how state laws should be tracked as interestingly as federal laws, because if you do business in that state, you will be subject to that those changes in the law.
Yes.
And I think we'll get
Okay.
into, yeah.
Jason, let me jump
Sorry.
in one quick second and say that that's similar to what we've seen in the privacy space as well, with California's law not applying to every company in the United States, but certainly applying to a lot of companies outside those that are based in California.
Yeah, and that's in briefly, that's a privacy law that essentially affects every company that does over $250,000 or something. As a sort of cap number, right? But if you do that much business in California, which lots and lots of companies around America do, essentially California is dictating the way that you handle privacy. Correct?
Yes.
So that's the one thing I would like, add here is that we're seeing a big shift towards state lawsuits away from federal. There's many reasons for that. But I think it's also very interesting to make sure now we have to track like what's going on at the state level because it really can affect the overall. Can we move to the next slide, Bethany? So how did we get here? What you've heard is this, which is lots of companies are getting sued, lots of small companies are getting sued now, not just big companies, right? What's interesting about, and maybe Christine, you could just clarify that a little better. When Christine talks about some case plaintiffs have been successful in state courts, it's not that they have actually won cases. They've essentially won the argument that websites need to be subject to being accessible and the ADA. And that opens up a whole potential legal roadmap, which is going to cost a lot of money to defend. And that's essentially the gray area of like what is accessible, what does the ADA require, is probably the biggest question that basically still exists for most businesses, right, Christine? So I wanted you to talk about, did we ever get close to knowing exactly what the ADA required of websites? What happened when we got close? And what's been the result of maybe missing that piece of clarification?
Yeah, absolutely. So this is a little bit of a let's take a step back in our Wayback Machine. So the ADA and in many cases, similar state laws prohibit discrimination on the basis of disability by places of public accommodation. And the ADA is a lawsuit that was signed into law in 1990. And so it predates the internet, at least as the internet exists today, and defines public accommodations very specifically in the statute. And it defines public accommodations as retail stores, restaurants, as including retail stores, restaurants, movie theaters, schools, daycare centers, libraries, and recreational venues. So the list of accommodations in the statute are all, at least on first blush, brick and mortar locations. And given the age of the law, the text of the statute does not specifically include websites as a public accommodation. The Department of Justice is the federal agency that has authority to issue regulations implementing the law. And those regulations were last updated in 2010. They are very specific about what it means for a physical location to comply with the legal accessibility requirements. They identify what accessibility barriers include, things like lack of curb cuts or not having ramps, spaces without sufficient clearance, doors that are too heavy, parking spaces that are not wide enough or that lack an accessible aisle. And for most of the ADA's history, that's what lawsuits focused on. which is not surprising given the statute and its implementing regulations, which plainly established governing legal requirements for physical locations. In the context of websites, the regulations just don't speak to them. And when the Department of Justice issued its last set of regulations on accessibility in 2010, it put out a request for comments concerning what requirements it should issue for website accessibility. And so if you look on the slide from 2000 to 2015, it was also bringing enforcement actions. And so it said, we're going to issue regulations, and started taking steps on website accessibility. Again, that was 2010. The comment period was open until 2011. The federal government has a calendar of anticipated regulatory action, and from 2011 to 2016, just about every 6 months, DOJ moved its anticipated date for regulations slightly further without ever issuing regulations. In 2017, they said, well, let me take a step back again. During that same time period, from 2011 to 2016, it was taking enforcement actions, and it took the position in those enforcement actions that it believed website accessibility was required even in the absence of regulations. And then in 2017, at the beginning of the Trump administration, it removed website accessibility regulations from the agenda altogether. And so as a result of this, of DOJ sort of kicking the can on this while saying, okay, we think that websites need to be accessible, but we're not going to tell you exactly what accessible means in this context. You've had the law develop in a very messy way. And you've had the law basically develop through settlements. And those settlements have all pointed to the Web Content Accessibility Guidelines, the WCAG. At first it was 2.0 and now it's 2.1, level AA standard for what accessibility means. But those sort of a large part of the problem here is that those are written as a standard by a non-governmental agency that just isn't written the same way that a legal standard would be written.
Yeah, and I think that context, so just in case we've got people who can't see the slide essentially showing the activity of DOJ involving themselves in cases before 2017, and then after 2017, they haven't involved themselves in any direct cases. But in 2017, the numbers of went from about 200 private lawsuits to 800 to 2,000 to 3,000 to 4,000 to 4,500. So essentially, this sort of lack of clarity opened up a what our class is a gray area, but allowed plaintiffs to argue, hey, your website should be accessible. Defendant could say, I think it is accessible. Plaintiff can say, well, you're going to have to spend a lot of money in court to prove that because there are no specifications, but we would take a settlement which is less than what we think it's going to cost you to argue that in court. Would that be a naive sort of paraphrase, Christina,
No,
of what's really happening?
that would be an accurate. That would be an accurate paraphrase.
So let's move on to think about, okay, well, could some of this clarity be be corrected in the next year or 2 years, right? So, you know, what's out there that maybe would help a business say, no, I'm sure we've done enough, and here it is. This is, you know, right now what's missing is what is enough, and an easy way for a business to prove they've done enough, right? So without that easy proof, a business would have to spend a lot of money to prove that they think they've done enough. And that's not what really businesses want to do, you know, spend their money, time and money doing. So let's look at some of the upcoming federal and state activity, and also, and you know, is the DOJ getting more, right? So maybe we start, Christina, just by sort of saying, like, what's happened in the past with regard to Supreme Court, New York, California, Florida. I know you've mentioned some of these. It might be you go over these quickly again and come up with a summary of sort of where we're at, which I don't, you know, I think you sort of given a color to, but I just want to make sure that we cover this slide.
Yeah, absolutely. I would say that courts are all over the map about when access is required. The Ninth Circuit has repeatedly held that there has to be a nexus between a website and a brick and mortar location. That standard went up to the U.S. Supreme Court, which denied cert a few years ago in the Domino's Pizza case.
Can I just inject there, just in case it's not obvious what nexus means? It essentially means that,
Oh, sure.
hey, there's a physical location and there's a website that you use to access that physical location. So, for example, find a store, order a pizza and pick it up, order a product and pick it up in store. That's a typical nexus of where the website has a direct connection with the use of the physical location. Is that correct, Christine?
Yeah, absolutely. Learn about coupons, submit your prescription online for pickup in the store. Those are the types of things that are, again, that nexus that the Ninth Circuit has required. We also have the Supreme Court considering standing questions about the ADA requirements, which is, what does a plaintiff have to show in terms of the harm that they have allegedly suffered in order to bring a case. And that case before the Supreme Court was mooted earlier this year, and the Supreme Court decided not to clarify those standing decisions. Some other federal courts, including those from Massachusetts, New York, Vermont, have said that all public-facing websites need to be accessible. But at the same time, given the numbers of cases that are being filed in federal court in New York, we also have some judges that are becoming a little bit more skeptical of the cases and looking for, I would say, docket management. So they're scheduling immediate status conferences or settlement conferences in order to move cases quickly off of their docket. In California, we've had some cases in both state court that have said that a nexus is required between the website and the business's physical location. They have also said that strict compliance with the WCAG 2.1 level AA standard is not, like, deviations from that standard are insufficient to show intentional discrimination under California's Unruh Act. And then in Florida, the 11th Circuit said that websites didn't have to be accessible. And so I guess my takeaway is that courts really are still all over the map on this.
Yeah, I think the takeaway is that the lack of clarity benefits plaintiffs as opposed to benefit defendants, correct?
That is correct.
Right. Let's look at seeing what we think might happen in going forward. I think one of the things I think is worth saying that you know, the DOJ has become active again under the new administration. They seem to have taken up champion particular activities like voting and prescriptions and healthcare. These are things that they feel passionate about in terms of, essentially trying to remind particular industries that they are actively looking for discrimination in specific areas. I think an important item is that they have progressed what they believe is a technical specification for Title II. So people who are unaware of Title I typically covers employment. Title II typically covers state and local services, so state and local organizations. And Title III typically covers everybody else, so commercial organizations, right? Title II, the DOJ is looking to put in technical specifications. That is meant to happen at some point. I don't know whether Christine has an idea of when that would happen, but I think more importantly, would that add any clarity to Title III cases?
A Title II regulation would not be directly applicable to Title III. And what we're seeing in terms of the suggestions for Title II is, again, WCAG, which is where we generally are in terms of our recommendations. One thing I could see happening is if you had state and local governments pushing back on the WCAG as the legal standard and pointing out some of the problems with enforcement or compliance with the standard, I think that could maybe get DOJ to take some action on Title III. But I think most of the current action is looking to would build on the current requirements that we see and probably not do that much. They would create additional requirements for businesses. I don't think anything would reduce the burden on businesses right now.
Right, because you're saying essentially the standards or the requirements on state and local is almost like the same as what is in all of these settlement agreements anyway, and essentially it almost gives plaintiffs another example of you need to do this because even state and local need to do this. That's my sort of feeling that how a plaintiff firm would use that specification. So let's talk about that. There are like rumors around like, oh, actually there's other proposed acts or proposed like amendments to the ADA sort of floating out there or have been out there or still maybe on the proposals dockets. Could you talk briefly about those level sort of proposed acts? What's your feeling about the likelihood of any of these sort of really seeing the light of day?
Yeah, absolutely. So there's three that we've identified on this slide as some areas where we might see the feds do something. One is the Communications, Video, and Technology Accessibility Act. This applies to television programming. There are already captioning requirements for television programming, and those have gotten stricter in the past few years. As I'm sure you could tell, we've seen we've seen a lot of progress and improvement in captioning generally. And that is a result of earlier versions of this act. The CVTA would expand those captioning requirements even more so that most, if not all, television programming would be captioned. The Online Accessibility Act would create a new Title 4 for websites and mobile apps. As we've talked about, the Americans with Disabilities Act currently it has 3 sections or 3 titles. It has Title 1, which is addressing the requirement, which addresses employment and how employers need to respond to disabilities. Title 2 addresses how state and local governments need to the requirements for disability, and Title 3 responds to public accommodations. The Online Accessibility Act would create a new Title 4 for websites and mobile apps, rather than trying to shoehorn those requirements into Title 3 for public accommodations. This is, I think, a better way of creating law. And if it had happened 15 years ago in 2010, probably would have been a good idea. I don't know that Congress today is going to, they don't seem to be making a lot of laws. And so I don't really think this is going to go anywhere, but it's an interesting idea that would certainly be cleaner and address some of the messiness of the current legal framework. And the Websites and Software Applications Accessibility Act, again, it says it would clarify that it's unlawful for entities covered by the ADA to maintain inaccessible websites and apps that exclude or otherwise discriminate against people with disabilities. These are ways of sort of closing what some see as loopholes in the law, or and no one wants to say, oh, that's not the law, right? By creating this legislation, we're not saying that it's not the current law. And so they want to just clarify that it is the current law. And this is similar to, I think, what we're going to see on the next slide, which is what's happening in California.
Yeah, and just to give the state legislation context, I mean, also, I think you could also talk a little about what you're seeing in New York. But again, just as we talked about in the front, right? State-based digital laws, so laws associated with digital properties, have a far bigger reach than state laws that used to be focused on accessibility of physical. So, it is, if you are doing any business in California, New York, or any states in America, you've got to be aware of what's happening in those states, because you are subject to them. So I think that's why it's important for us to talk about California, because they seem to be most progressive right now.
Right. And so actually, most of what we're seeing is that the New York courts have been more progressive. And so we're seeing less by way of legislation. In California, because courts have chipped away at some of the accessibility requirements, or made, I don't want to say chipped away at the requirements, but they have been less plaintiff friendly. In terms of how courts have responded to claims by plaintiffs in this context. California's legislature is now looking to sort of undo what we've seen happen in the courts. And California Assembly Bill 1757 would require that all California websites follow the WCAG 2.1 level AA, and would create specific causes of action against the third-party developers that create non-compliant apps and websites. And so companies like that would be sort of targets for litigation, both from businesses and from disabled individuals. And so that is a big change. And we would, I think, see a lot more litigation in California if this bill is enacted. I want to talk for a minute about the Kansas Act that's referenced in the law, the Act Against Abusive Website Access Litigation. Just because this is a very different law. And this law gives businesses that are based in Kansas recourse against serial litigants that are suing them in states like New York, and would allow them to recover, to sue those litigants in Kansas and recover fees paid in sort of out of state litigation. And that is a very different take than we're seeing a lot of other places, but interesting.
Yeah, I think that both of those we need to keep an eye on. And then just finally, just wrap up sort of the legal landscape. I wanted to get your input on international laws that people should be aware of. Again, I think that if you're doing business in other countries, in other regions, again, you're going to be subject to their laws if they create laws around digital accessibility, in the same way that, you know, if they've created laws around privacy, you have to handle people's information from those countries in a certain way.
Yes, so we have the European Accessibility Act, which is imposing requirements. This is the first time we've seen that. And those requirements come into effect, I believe it's later this year. And then the Accessibility for Ontarians with Disabilities Act has requirements. These are all going to be similar requirements to what you're seeing in the United States. But I think the way that both Ontario and the EU enforce things, enforce their laws, is very different than how they're enforced in the United States. And I think so this can create exposure for companies that are doing business globally, because their enforcement mechanisms are much more like regulatory in nature and regulator driven, as opposed to these private lawsuits that we're seeing in the US. And so this creates an added level of exposure for companies.
That's great. And then maybe we, quickly go over what are the options if you get a claim, and like maybe like how I would position it, Christine, is sort of like, what is the first one or two conversations you have with clients who come to you with a claim? Like what's the first conversation and what's the second conversation? I think these two slides sort of cover that essentially.
Yeah, can you just remind me what's the next slide quickly? Can you
yeah,
okay.
If there's no motion.
Okay, great. So let's go back to slide 15. Okay, so when I have companies call me, the first conversation we have is, where are you on accessibility? And this is this is the first step. Where are you on accessibility? Have you worked with a vendor? Have you talked about this internally? What have you been doing to develop an accessible website? That's always an important first discussion. And then we talk about, what do we do about this particular claim, right? What are the possible defenses for a motion to dismiss? So a lot of this is, it depends on which jurisdiction you're sued in. But we talk about the legal issues that you might be able to use to defend your case. And those include, like, is there jurisdiction? Has the plaintiff sufficiently alleged that they've been harmed? have you, since learning about this issue, taken steps to make your site accessible? Is there a nexus between your website and a brick and a physical location? Is there an argument that there hasn't been intentional discrimination because you're able to establish that you have policies and practices in place to develop an accessible website, and that the only issues are sort of minor deviations that are not true accessibility barriers? So we talked through those sort of defenses for a motion to dismiss. And the reason that I mention that is because this is because of how plaintiffs seek a quick settlement, and the cost of, again, proving that your site is accessible, it is high. A motion to dismiss in some instances can be a cost-effective alternative to end the litigation. And then, because if you are not able to dismiss a case, and now we can go to the next slide. Litigation requires like upfront filing an answer. Now that's a pretty easy pleading, responding to the allegations of the complaint. But then there's an initial conference with the court. The court sets a schedule, and both fact and expert discovery about the allegations of the complaint and about the accessibility of the website can just be extremely costly. You then get to summary judgment, where you would argue that your site is in fact accessible, and that there is no claim here, and possibly a trial, because that is largely a fact question. And the Americans with Disabilities Act does not have does not allow plaintiffs to recover their money damages, but they do allow a plaintiff to recover their attorney's fees. And so the pricing of settlements largely takes that into account and encourages settlement rather than extensive litigation, where you could be on the hook for both your attorney's fees and the attorney's fees on the other, or for the plaintiff.
Yeah, and I think this is just to add into the context of here. So I think we'll summarize up, right, is I'd love to sort of understand that, like, as I understand it, 95% of claims typically settle, right, end up in some type of settlement agreement. And I think it's worth people understanding what's in that settlement agreement typically, because that's essentially what people should be preparing to do if they've not received a claim, because essentially that would put them in a good state if they did what's in a typical settlement. But also think about, if they do get a claim, or if they've had a claim, this is really what they're going to have to, think about resourcing.
Absolutely. So typical settlement agreements, including those with the Department of Justice, if you were to be named in a DOJ complaint, or those with private plaintiffs, typically require remediation of the website in some period of time. And the period of time can be short, it can be long. It can depend on your business's resources and the ability in order to achieve substantial conformance with the WCAG 2.1 levels A and AA. We're seeing some plaintiffs ask that accessibility widgets, or certain accessibility widgets, not be used as a part of the remediation. That's a more unusual provision, but we are seeing folks attack accessibility widgets. From my perspective, I think that accessibility widgets could be used as a part of any compliance strategy, but they shouldn't be the sole thing that you're doing in order to work on your website accessibility. There's usually a monetary payment of some amount. And in some instances, some plaintiffs are asking for a change in policies or practices. They're asking that you test your website or engage in training programs for people that are responsible for maintaining the website. The settlement agreements are generally, the specific terms are confidential, as opposed to the DOJ settlements that are public documents.
So what are our key takeaways between us? And maybe I'll take a couple and you take a couple, but
Sounds good.
you know, I think there's some good news and some bad news. The bad news is that there's a lot of energy in the plaintiff world and plaintiff bar that are looking for websites to essentially create claims against. The good news is that it's a volume business, so they're not spending lots of time and energy digging really deep into your website. So I typically sort of think about like, the low-hanging fruit is to essentially do what the plaintiff firms are doing, which is get someone who is blind to use a screen reader, get an initial feeling of whether that person can do all of the things you expect them to do on the website. If they can't, try to resolve them. Go out there, use a free testing tool. Usable has one on its website. That will give you sort of what our class is like high visibility issues. Typically, this doesn't make your entire website super accessible, but it will make it more accessible and will reduce the amount of visibility that you have against conforming with the guidelines. I mean, I love your input on the first one we talk about, Christine, which is like building a case. You know, where does the legal part, fit normally when you start talking to a company about building a case for action, like building a case for remediation?
Yeah, I mean, I think that the lawsuits are a piece of a business case for accessibility, right? Which is that if you don't do this, you are going to face a lawsuit. If not now, then within the next few years. The volume is just such that this will be something that you'll have to deal with. But the business case for accessibility is broader than that, right? It is 2024, and there is a business case for accessibility separate and apart from any legal requirements and any legal risk, right? Which is that you want your site to be accessible to consumers and clients with disabilities. And so the business case should be a mix of here's our exposure and here's the benefit that we'll be achieving in terms of access to a group of consumers.
Yeah, I put that in. I mean, to bring it back into human terms, right? It's about if you're a company and there's consumers that can't use your site, that doesn't sound like a good business, right? So one is about supporting consumers, and to be aware that these lawsuits are brought by consumers, right? So these lawsuits are not brought by the government; they're brought by individual humans, right? That are consumers. I'd also say that one of the best things that you can advocate for about making your website work for particularly this community is how loyal this community is. So, once someone finds a website that does what it wants, what they want, they will stay with that website because of that their sort of risk reward to go to another website is even higher than most others. So it's a very loyal consumer base, and that's one of the things I'd add to that. The The only other thing I wanted to make a point here, because we have a lot of people who sort of join these types of webinars because they may have just received a lawsuit. They've been told to sort of take care of it, right? Hopefully what's come across is it is a very specialized area. Like, so one of the things I think you're going to benefit from is having some external counsel that knows the 10 or 15 plaintiff firms, understands their sort of playbook of what they're trying to achieve, and can quickly get you to a place where you're less distracted, you're less concerned, and it feels more manageable about what these types of lawsuits are. And I think that what we've seen with our clients is, you know, once you involve someone who knows this, it becomes a lot more manageable and a lot less anxiety around what is this claim, and, you know, how big is this going to be in terms from a cost factor and from a work factor.
And I'm going to go ahead and close today's webinar.